All right. Good morning, everyone. Welcome to our IoDZ webinar, or where we are going to unpack the New Companies and Other Businesses Act. And with me today is Mr. Mushayi. He's going to be taking us through the Companies Act. He is the Deputy Chief Registrar of Companies in Zimbabwe. Welcome, Mushayi.
Good morning.
Morning.
Thank you for having me.
All right, and our meeting today is powered by Sande. We would like to specially acknowledge our sponsor, Sande, for bringing us this webinar. And over to you, Blessing Bugude, the underwriting manager from Econet Wireless, is also one of our sponsors. Blessing.
Good morning, everyone.
Guests.
Yeah, thank you. Good morning. Welcome to this webinar. We're grateful to IoDZ for giving us this opportunity to just host everyone and walk through the New Companies Act. Econet, as you know, is a popular brand. Within Econet, we have a wide array of products, but today I would want to talk about the insurance side of the business. The insurance side of the business is housed under Cassava. Cassava is a technology-based group, and within it we have EcoCash, we have Stratbank, we have Econet Insurance and Econet Life, and these two are our entities within the insurance entities within Cassava. The Econet Life brand looks at life insurance products specifically. We cover about any kind of life insurance that you can think of within the Econet Life brand. Our popular and flagship product is called EcoSure Funeral Cover, which is registered on the phone. Then we have Econet Insurance, which looks at the non-life products. So if you can look at the Cassava group, we are so privileged that we can cover the life and the non-life products. On the non-life side, we have our flagship motor insurance product, which is about the only one in the market where you can buy your insurance, your ZBC license, your Zinara license, right on your phone. And it can be any phone that you can think of. It doesn't need to be a smartphone. So you can dial on your USSD right now, even on the feature phones, they're not smartphones, then you can purchase your insurance straight from there. But specifically for the directors, I think it's very key for us to bring it into context with what we call the Directors and Officers Liability product. This product looks specifically at the directors as they are executing their duties, to say that in the event of any liability that may emanate from you as a director carrying out your duties, any liability, whether it's being sued by shareholders for them perceiving you to not have carried your duties up to standard, we have a product which is specific to that, which can then take care of any liabilities that emanate from the decisions that you make during the course of your duties. Specifically, this product looks at any liability, any you being sued for any decision that you have made during the course of your duties. Then we're moving away from the director's liability. We have another a wide range of other non-life insurance products. We cover engineering, we cover fire, we cover motor insurance, we cover all other liabilities that emanate from the businesses. And I know we are battling with inflation, which is around 600,000 according to the IoDZ in March, 600%, sorry, according to the IoDZ in March. We have a product that ensures that you are always fully covered. I know those who have experienced claims over the last 12 months will know that sometimes the insurer tells you that you're not adequately covered. We have a product which is specific to our companies, to our corporates, to our individuals, which make sure that you are adequately covered at all point in time. We call it the index-linked product, a full indemnity product. This product ensures that you are covered at all times of all periods of the year, and it tracks any changes that happens to the market value of your product. So let's say your vehicle today is worth 100,000 Zimbabwean dollars. By next week is worth 120,000 Zimbabwean dollars. We ensure that you are covered adequately through that period, so that we don't talk about average to those who have encountered such issues, to say that, you know, we're not adequately covered, then you are paid a portion of your claim. For us, we ensure that you are covered up to date through the index-linked product, which tracks the value of your sum insured as it increases with the product. Like I said, we are part of a big group, and together we can bring to products that well suited for our directors. We can bring together products from the financial services, which is EcoCash Insured Bank. We can provide for you products that range to the agriculture side, whether it's insurance or it implements the tilling itself with our EcoFarm product in our fire tractors. So as you look at cassava, and as you look at Econet insurance, we are there to save you from a wide range of views depending with your needs. Basically, that's what I can say as an overview of Econet insurance and cassava. Should you have any inquiries that you may need, we have the emails with the organizers. You can get in touch and we'll be able to save you.
Thank you very much, Blessing, and we value your sponsorship, we value your partnership with IoDZ in bringing us this very important webinar, where we are looking at the New Companies and Other Business Entities Act. And this is a remarkable development in terms of our legislation, Mr. Mushayi, isn't it? And we do look forward to you taking us through it. Over to you, Mr. Mushayi. You can just take us through your presentation and the highlights that you would like our members to take note of and our guests to take note of over this New Companies and Other Business Entities Act.
Yes, good morning, and again, thank you for having me. It's indeed a wonderful development, and we're so excited about it now that we've started implementing it. So for the next few minutes, bear with me. I will take you through the background, the journey, and where we are now. Okay, we're just sharing the presentation. Okay, thank you. So for this session, I'm focusing mainly on the key provisions of the Companies and Other Business Entities Act, Chapter 24.31. It would also help if I just share with you the brief background of what we did together with our co-partners and stakeholders in general. This exercise started way back in 2015 when government realized that we were performing very poorly in terms of World Bank ease of doing business rankings, and also there were submissions from stakeholders to say, you are not doing fine, why don't you review the operations in general? Not so much about the Companies Act, but generally ease of doing business as it involved government. So World Bank proposed that we start with the legislation because it was discovered, not that we didn't know, but also emphasized that we needed to review our Companies Act, which had last been reviewed in 1952. Well, it was a strong legislation, good and well done, but it had fallen out of favor simply because it was no longer in sync with modern business practices. And also it was silent on ICT in general. So an effort started immediately with World Bank sponsoring an exercise where they even hired consultants to assist with the process. The first draft was not very good, simply because I think it was rushed through. So eventually the Attorney General was tasked in 2017 to actually draft from framework of the existing legislation. And then it was discovered that you can't improve on the existing legislation, that is Companies Act chapter 24.03, but we needed a completely new legislation altogether because there were too many changes that needed to be inputted. And that's what Attorney General started doing in 2017. And then the zero draft, I think it came out mid-year that same year, and then PA review sometime towards the end of 2017. Thereafter, it went to Parliament. It was first reading. I followed it, fortunately, throughout all public hearings by the Parliament, and it was quite exciting to note that people had such a disinterest in the bill. But nevertheless, we took it through to Bulawayo, we took it to Masvingo, to Tare, to Harare. We had active participation, fortunately, where we had a sizable crowd of 4 people. And in Harare, it's also comforting to know that people took huge interest when it became law. But now that we have it as a law that is in around October 2019, it gave us 90 days within which to implement. And immediately after it became law, we started outreach to find out what our stakeholders would say about it. And a lot of submissions have been coming through. Now I'll take you through. So the new law has got several changes that it is introducing into our legislation. For the first time, it's creating what is called the Companies Office. And it's also bringing a new concept of assumed names. Many of you would know it as trade names. Also, it's introducing an item called replacement of lost, defaced, and destroyed documents. Previous to this, we didn't have any provision in the law for replacement of lost documents. We didn't have provision for replacement of defaced documents, but now the replacement is possible. Inspections and investigations, this was absent. The only inspection that was mentioned in the previous act was that commissioned by the minister, which to a great extent was unusable. Next to that, it introduces some of the common law provisions which are now codified in our law. I'm talking about the duty of care by directors, and also business judgment rule, and also issues to do with corporate governance, which are really welcome. Disclosure of beneficial ownership, this is in tandem with the commitments we have made as a country to certain international obligations, and also generally to curb against money laundering and financing of terrorism. Mergers and takeovers, this has been absent, and now it's included in our bill. This is the first time that Zimbabwe has actually included something to do with mergers and takeovers. And corporate governance, I've already mentioned that. Civil penalties, a lot of the criminal penalties provisions in our previous act have been reduced to civil penalties, simply to decriminalize mistakes by officers and directors. Also, electronic registry, I did mention that our previous act was silent on ICT. Now there is a whole provision to do with electronic registry and transactions. Re-registration, a lot of exciting issues there. Re-registration is simply put in place to make sure that we clean up our registry, and also we bring in sync all companies with the new law. This is just a brief summary. I'll take you through the provisions. A lot of complaints have said, oh, it's too big, we can't finish this, or why don't you make it simpler and smaller? I think this is a very simple law. It's very easy to read, and the non-lawyers have been able to read it and understand it. And also it's smaller than the previous law. Many people doubt that, but it is. The previous law was actually 365 sections. This one is 304. You have a smaller law, I think it's usable. Good. Now, in brief, I will, okay. Right, we know that already it provides for the incorporation of the constitutive documents, administration, and also companies and private business corporations. Over and above that, it also provides for the registration of voluntary business entities. I mean, all associations that choose to register with the office are welcome to do so. There's no provision for that because we have a lot of viable syndicates, organizations, associations that would want to get registered for purposes perhaps of facilitating business transactions that is now provided for, and also for voluntary wind-up. You know that the previous legislation also included liquidations and the insolvency issues that have been removed in total to the Insolvency Act. That because it created confusion with the Master of the High Court. Confirmation of registration, repeal of Companies Act, okay, that's part of the process. It repeals these two acts, that is the Companies Act Chapter 24.03 and the PBC Act Chapter 24.11. For the first time, it actually creates an office called the Companies Office, which can be sued and can sue in its own name. And this was found to be important, seeing that the office is evolving and also assuming a bigger role than the previous office, which was more of a section in the Ministry of Justice. So the intention of Section 6 is really to create a separate office. And I must also add that there is already administrative measures being taken to literally create the office and equip it separately. And some of you might know that the lumping together of the Companies Office, Deeds Office, and Intellectual Property was more of a colonial vestige, which came from Cape Colony and was really for administrative convenience, mainly because it was easier to manage these offices together because they didn't have sufficient business to carry out separately, but now it's different. So an office is being created for that purpose. The registrar, the chief registrar of companies, is also expected to release a report at the end of financial year detailing the events and what took place, informing the minister and parliament of what took place and the intentions in the coming year. Okay, in terms of electronic provisions, business entities are required really to come into agreement and association with the office, mainly because these arrangements must be managed and people must be traceable. Whoever deals with the office must remain traceable. So there is provision there to enter into an agreement. This is mainly to do with service providers, people who do business, register companies on behalf of others for profit. They really need to get into an agreement with the office so that we maintain the integrity of all registrations. Okay, as far as the law is concerned, we have had concerns that, oh, your law is very big. Are you going to be able to unpack it and release it and implement it? And therefore, I remember in our first engagement, we had issues. People saying you need 2 years to prepare for this. I believe they were borrowing from South Africa where they needed more time to actually implement. I really believe that we can implement it and improve it if we find perhaps gaps in terms of implementation. But now, how do we implement it? We are implementing through regulations, and we have SI 46 of 2020, and we have SI 46 and 47, one to deal with regulations and the other one to deal with fees. You will find that our regulations have departed a lot from the previous regulations in the sense that these have been refined to make sure that they're readable, and also they talk about pre-incorporation and post-incorporation so that you know exactly where to go and it directs you on what to do and how to complete forms. So I've included a structure of how the regulations are actually drafted, and maybe we go into detail later. Let me go straight into the meat of the presentation. So I'm just highlighting on the new issues. Now, in terms of name searches, many people were used to the previous forms, but now we have a whole lot of new forms. We moved from 23 forms to 35 forms. So it's from 1 to 35, and all these forms have been renumbered. So if you have old templates, you need new templates now. And the contents also have been improved. They have been streamlined. because everything, especially regulations, they've been designed with ICT in mind. How do we further simplify? How do we make it possible to have it online? Is it easy or is it difficult? So that was the intention of the review of almost all forms. Okay, so you find that some forms have now been merged, so that where you have separate forms, you had separate forms for PBCs, separate forms for companies, those have been merged. Now you have the same form applying for a company, the same form applying for a PBC. That is simplified. I think it was for the benefit of the user. Then you can actually object if you see somebody applying for a name and you believe the name belongs to you and you are not in agreement, or for whatever reason, you can apply to the registrar to say, I don't think you should grant that name. This is third party, maybe third parties can actually submit an objection to say, we believe this name, for whatever reason, and the registrar is compelled, or rather expected, to respond to your request, and also, where necessary, go through a process to determine who actually should use the name, or if the name is perhaps offensive for whatever reason, it can be dropped. This process was missing in the previous legislation. It was there, but not yet quite complete. Now it's very comprehensive. Assumed names, I've already mentioned that the law provides for assumed names, which in most common language, we call them trade names. Now you can choose to call your business by some other name. Mainly this comes as a result of actual conduct of business, where maybe slogans become more popular than the incorporated name and you'd want to protect it. Now there's a way of doing that. You apply for the name, you get the name, and then you get a certificate in the form of a CV5 to say that this assumed name belongs to you and it's protected under the Companies Act. Nobody can then piggyback on that or use it. The only way to protect assumed names in the previous legislation was going through a trademark process, which again is a separate process. Replacement of lost documents, I've already talked about that. You can actually request the replacement of documents that are missing in the file or that are no longer readable or legible. There is now provision for that. Now, this has been criticized to say, isn't this being thinking along the manual system and maintaining the analog system? Well, true, it is, but if you notice, the law allows a parallel process for the meantime, so that those who want documents replaced now before the electronic system is live can still replace them. But once the electronic system is in place, maybe there's no need for it because the documents will be electronic and available. Okay. So I've been talking a lot about companies, but for PBCs, what has really changed? What has changed is mainly the forms have been standardized, streamlined for electronic purposes. And also, for the first time, the PBC is receiving a certificate of incorporation. Previously, they didn't need a certificate of incorporation, but now they're receiving a certificate. This was due to, there was a submission by stakeholders to say, how do we know it's incorporated? It's not enough to have an incorporating statement. Let's have a certificate. So there's an output document called a certificate of incorporation for a private business corporation. They also have an annual meeting. Stakeholders demanded that if they are going to be a viable business, they need to meet once in a while and discuss these things. So they are required to have at least one annual meeting, and they can also apply for an assumed name. Those are some of the changes. Private limited company, which is the most popular business entity registered by our office, and the due process is that you apply for a name, which when confirmed, you then proceed to submit constitutive documents together with a list of directors and secretaries and registered office address, which must include an email, and of course with the prescribed fees. And together with, now there's this issue of objects, you see, you state your objects. But now with this law, in terms of section 77, you are not obliged to state your objects. You can move straight to just state that you are incorporated, and you then state your subscribers without necessarily mentioning the objects. Although tradition is very powerful and it's not easy to break, people are still submitting memorandums with objects. But if you are incorporating a company limited by guarantee, it's still a requirement. You need to state your objects because the object is the whole purpose of the incorporation of a company limited by guarantee. And of course, if you're incorporating a public company, you need to state your objects. Limited companies, those are public companies. They follow the same process in terms of incorporation, but they've got additional requirements when you, in terms of documents accompanying your constitutive documents. These are like registered office address, which again should include the email, list of directors, which you definitely must include the secretary, who must be qualified to be secretary. Consent to be a director, the director has to confirm. Affidavit by directors, if they're taking up shares, they must confirm which shares they're taking. Copy of prospectus or statement in lieu of prospectus. It's necessary, it's still necessary. Okay, that's a limited company. Limited by guarantee, these are not so common, but they are necessary for society. These are companies that are formed not for profit, and usually they are associations, charity organizations. I know some people will say this is duplication. Why don't you release it to the PVO? Let it be done by Ministry of Social Welfare. Yes, we tried that, but there are some which do not quite fit as NGOs. They are simply association of, let's say, a club. Why should it be treated as a PVO? It's not a PVO, so therefore this provision was retained. Unfortunately, this one also requires the license by the minister. Therefore, you still apply to the registrar, who then recommends to the minister, who then approves. When he approves, that means you need to then advertise so that third parties can comment to say, should this association be allowed to incorporate as a company limited by guarantee? In case somebody objects, let's say you're doing it as a church, some people might say, look, no, we don't believe our church should be incorporated as a company. This is not acceptable. So objections come to the registrar after advert, who then calls for a hearing if there is need for a hearing. Or if there's no need, he then advises you, no, there's no need, submit the complete set of documents, and then he writes to the minister, who then releases a license. After the license has come, the registrar will incorporate your company as a company limited by guarantee. You can see that it's quite a process. This is deliberate, really, so that anybody who really incorporates, because once incorporated as a company limited by guarantee, you are taking public money, either in terms of donations or in terms of subscriptions, and therefore it's necessary to make sure that it's as tight as possible. All right, this is what is new in terms of company limited by guarantee. I've already gone through this. I think I will pass. Shell and share of companies. There was a lot of criticism to say, why are you even retaining it? Why are you even keeping it? We don't want share of companies. We don't want share of companies. Yeah, indeed, it may not be necessary, but there's a reason why people want a share of company. These are companies which are really not in business. They are not really doing much business. They are being held on the shelf for purposes perhaps of investment or for purposes of selling to the third parties who may want it. And as such, they have a special provision in terms of Section 293, where if you are incorporating share of companies, you must declare to the registrar that these are share of companies, and therefore, if you incorporate many of them, they attract a discount. If you don't maybe meet the threshold of at least 20, I think, you pay a premium. And they have a shelf life of 12 months, which means if nothing happens to them in 12 months and you have not submitted returns, they are taken off the shelf and struck off the register without further due notice. So this is a simplified process of cleaning up the registry in a way. Public companies. Okay, in terms of public company, I just threw it in there so that we remind each other that if you are involved with a public company, there are certain things you just have to know. It's no longer easy to be just an officer. You need to know certain things, like the functions, qualifications of company secretary. It's mandatory. You need to know what you are doing. Not to say others didn't know, but just to emphasize. Further obligations for directors. You can't just be appointed and say, I'm a director in 52 companies. You got to know what you are doing in those 52 companies. In any case, we have limited it to 8. If you read carefully, you find that there's now a limit. Okay, corporate governance, it's now part of our law. It used to be part of the common law. You were expected really, certain things were almost common cause, but not anymore. It's now in the law. Protection of shareholders from the board, runaway boards, very common, where the board becomes so powerful, they don't have AGMs, they don't declare dividend, complaints come to our office, and sometimes we are powerless to intervene. Now, at least the act is very clear. There are no gray areas there. The shareholders are protected, including minority shareholders. Declaration of holding AGM. We have delinked the submission of annual returns from AGM. The AGM is still there. So there's now need for public companies to notify the registrar that indeed we held an AGM. It's impossible for the registrar to know that a company has had an AGM. And it's now a requirement that they file a form to say, we held our AGM and it's on file. Therefore, whoever wants to make a search or is doing due diligence can confirm that. Beneficial ownership. I mentioned that in terms of protection of the country and the public and businesses from money laundering and also preventing money laundering. We need to implement certain measures. We already have a Money Laundering Act, and it specifies the details of how that money laundering can be controlled or prevented. And also sponsorship of terrorism. And therefore the registrar is expected to implement certain measures. So the only place where the register of beneficial ownership can be kept is found to be the register of companies. Therefore, there is a new register for the registrar, and this is to record beneficial ownership, which means really if you own shares in any company and the threshold is 20% and above, and you are maybe you hold shares as a corporate or as a trust or as whatever you use as a vehicle of investment, eventually we need to know who is behind the vehicle. Now, this is public and yet confidential. It sounds like a contradiction, but it's not. There's a reason why people want to be anonymous. Good reasons, very good reasons, business reasons or personal reasons. So we would want to maintain that confidentiality, but at the same time, when the need arises that it must be disclosed, let's say by law enforcement agents or by whoever has a court order to actually search the register, it must be available and it will be available. So there's a register for this purpose, and this register is not open to the public, but it's open to the required people who may need to know. So it's a need to know basis. So there's a declaration which you file with the office, which declaration is then recorded and registered, and you'll be notified that it's registered. So when the threshold changes, let's say you fall below 20%, you again need to notify the registrar so that you are removed from the register. It would be erroneous to keep your name there if you are now below the threshold of 20%. And if indeed you go beyond the 20% or beyond the 40%, again, you must continuously update the registrar. If you don't, there are civil penalties for not informing the registrar. So it's enforceable. Okay, this is the form that you complete and you submit. It's called a CR16. I'll pass. Duty of care, loyalty, business judgment rule. This is new to our legislation, but not new to business. It has always been there, but it's now codified. And in US, I think it's called business judgment rule. In South Africa, I think it's the same. I think the South Africans borrowed from the Americans, and we borrowed from the Americans and the South Africans. We borrow from each other. It's allowed. So every director is expected to perform in good faith. I've highly summarized here, in good faith, in the best interest of the business entity, with care, skill, and attention of a diligent business person. So if you are appointed as a director, you cannot afford to be ignorant of what's going on. You cannot afford to avoid knowing details. It's not micromanaging, it's just keeping yourself abreast of, and it's important to be a director where you can apply your knowledge and your skill. Where you have no knowledge and skill, you need to acquire that knowledge. To be fully informed on the subject to the extent appropriate, and has a duty to act with loyalty to the business entity. There's been criticism to say, are you sure that it's clear what is to act with loyalty to the business entity? Well, it's debatable, but some of these details can actually be maybe more specific in the contract itself. Corporate governance, section 220. This is a welcome development, and it's a necessity now for the board to put in place and to adopt corporate governance guidelines. Of course, most of them have already done so and are already doing so, but it becomes mandatory that it is part of your governance system. Some people would say, was it necessary to put it there? Indeed, it was, seeing that some companies didn't do it. So now everybody is expected to do it. The only unfortunate part is that this does not affect parastatals. Yeah. Well, I don't know. Maybe you can would want to hear what you think about that. Legal practitioners. Now, this has been ring-fenced generally to restrict those who want to do business on behalf of clients to legal practitioners, chartered accountants, public accountants, auditors, chartered secretaries. Some people were saying, why are you restricting it to a few people? We also want to be part of that. We really believe that this is a serious business and it must be done by people who are qualified to do it. So that was why it was ring-fenced as it is. Registration. I know there's been a lot of questions, some of them submitted to me directly. Why do we need re-registration? So in terms of section 303, a company or a private business corporation must re-register under its existing name without prejudice to its right after re-registration to change its name under section 26. So re-registration is a requirement. Why is it necessary? The object of re-registration is simply to establish a new and updated register of companies and private business corporations, because the current register itself is full of defunct companies, some of them that have not been renewed for many years and are not active in business and are no longer perhaps attended to by whoever registered them. So it will be necessary to flush them out. The current process of having to write letters and then expect a response is too slow and may not work. So the intention was to take advantage of the current review of the law to also deal with this issue and therefore expunge defunct business entities from the register. Some people were saying, isn't it punishing the existing and functioning companies because you have a problem with non-functioning entities? Not really. It's also an opportunity for existing companies really to update themselves and make sure that correct information is on the register. Because if you are a performing entity, you would want the companies to be up to date and also to make sure that the available data is of such integrity that it is dependable. So it's also a verification exercise. Re-registration is not re-registration. What do I mean? I mean that it does not create a new legal entity. Neither does it affect or prejudice the identity of the board corporate. You remain who you are. Does not affect the property, the rights and obligation of the entity. Your property remains your property. Your rights continue to be your rights, and your obligations to the banks. You can't run away from your loans. You can't run away from your security. You still have to own up. Even if you re-register, yes, you are still the same person. Affect legal or other proceedings by or against the entity. If there's a legal proceeding against an entity, if it re-registers, it cannot say, I'm no longer that person, I'm born again. No, you still have to attend to the proceedings. Okay, so if you are pursuing a matter as well, even after re-registration, you still pursue the same matter. Okay. Bona vacantia, maybe before I go to bona vacantia, let me also say that I've already submitted with the Attorney General, and of course the boss is meaning the permanent secretary, and I have requested that we review the re-registration deadline by 24 months. I have reasons for that. I don't know if I should continue.
Yeah, number.
Inquiries already.
There are a number of inquiries already, and maybe you'd want to get into that before you continue, so that we don't lose our audience.
Okay.
Yes, but before I go into some of those questions that are coming in, I want to acknowledge once again our sponsors, Mover, insurance. For your Mover is your all-in-one insurance partner that gives you more value for your money. Move over to Mover by getting insurance cover for your vehicles, property, household contents, and personal belongings. Renew with Mover and enjoy the convenience to renew insurance from the comfort of your home or office by simply dialing *901#. There's a 10% no claims bonus, and this can accumulate up to 50%. Free miles ambulance service in the event of an accident, free delivery of your insurance discs, free vehicle towing services through Automobile Association of Zimbabwe. So for you to sign up to Mover, just dial *901# or reach out to Mover underwriting team via email underwriting@calsafasmartech.co.zw. So there are a number of questions coming in. There are a number of questions I also had prepared for you, Mr. Mushayi. You talked about ease of doing business. Do you think that the new companies and other businesses entities act as it is in its new form does actually help the country improve its ease of doing business index?
Okay.
Okay. All right. Yes, the law is the vehicle, the infrastructure upon which we can then implement the administrative measures that will help the country improve our business, ease of doing business in general. And it is sufficient provisions to help the country improve in terms of rankings. Now, what we need to do is to implement the measures that are actually stated in the Act itself. And to do that, we need tools, and those tools include ICT. And as we implement the new law, it is also necessary that we bring it up to speed. We bring the office up to speed, and we bring our stakeholders up to speed, so that together as a team, everybody implements. Even when the officers implemented the ICT, it's also important that our stakeholders also implement, so that we don't get people still bringing in documents, paper-based documents, even when the ICT function is available. So the ICT is one of the things I'm going to talk about, and I think there are a few questions. Yes, to answer you, I believe this law will help us improve our ease of doing business rankings.
All right, apologies, I had unmuted. I would want to know in terms of our small businesses. As you know, our country, most businesses are informal or small entities. Our country is basically being run mostly by the SME sector. Do you think that this new act has the provisions that will promote small businesses and that will encourage them to formalize their activities?
Thank you for that question. We have had complaints previously by small to medium enterprises to say that the process takes too long, and also the cost of starting a business. So I think the two factors that affect formalization are the processes. They must be simplified enough to allow an ordinary person to be encouraged to actually incorporate. Then also the cost of doing business. So you find the PBC has been kept fairly affordable in terms of incorporation to allow them to incorporate without incurring a lot of expenses. Further to that, we do know that most of the SMEs, they were not very happy with the private business corporation, the PBC, because they didn't get a certificate. Because what banks want is to see is your certificate. And also where they do business, they want to say, where is your certificate? People are used to seeing certificates. So because of that, there's now provision for certificate for a PBC. And also financial institutions, they were very nervous about PBCs if they don't have an annual meeting. at least they needed some summary of what they were doing during the year and their intentions. So now there's provision for that. So I think those are balancing sections that have been put in the legislation to allow all stakeholders really to contribute to formalizing our informal sector. And a lot of them are actually coming in. Yesterday, I received a phone call from somebody who represents a group of youths in a certain province. They want to come in as a group and incorporate separate PBCs. And I think there were about 100. They're excited about the law. They just discovered the regulations, and they believe with this arrangement, they can go into business and perhaps contribute to the economy.
All right, thank you very much for that. There is one of our guests, Patricia Mrambinda. She wants to know, is there any penalty if a director sits on more than 8 boards?
Well, yes, there is penalty. You shouldn't do that. There are civil penalties. I would not know offhand the actual penalty now, but I think it's category 1 or category 2 civil penalties. To answer that, yes, there is a penalty. It would be advisable not to exceed the threshold of 8 boards. So far, we've not received submissions to say 8 is too little, but it would be good to hear what maybe business thinks.
There are also questions which came in before the webinar, and people really want to know what's new for the directors in this new act. Because, you know, directors are concerned, are there any new additional liabilities for them? Are there any additional responsibilities for them as directors of companies?
Thank you for that. I think I went through some of them. That is the issue of business judgment rule. Let me see if I can quickly go back. Yes. So some of them were already incorporated in corporate governance and also part of the common law provisions. But now that they are codified, it's now very necessary that everybody who is a director, at least they must satisfy the duty of care, the duty of loyalty, and business judgment. So those are the new provisions. And there is a clear demarcation between director and secretary. You can't be both. And there is also separation between director and shareholders. This applies to public companies, not private limited companies. Those husband and wife companies can continue where perhaps the wife, without even knowing she's a secretary, she's a director, those ones, we know those arrangements exist and we would want them to continue to exist. But when it comes to public companies, we need to be very careful because we have had problems before. And I know for sure that a lot of these submissions really were coming from stakeholders. And we would want to make sure that this is internationally recognizable and benchmark against any economy and any system anywhere. So the law is meant to take care of interests of the business, not so much of the people.
All right, thank you very much for that clarification. You've talked extensively about the namesake and the creation of an electronic register. So how does this address issue of duplication of names and issue of maybe issues of passing off, whereby the names are so similar to each other that is different, it's difficult to differentiate between the two. So as you embark on your re-registration process, you say that this does not imply that this is a new entity, but what will happen where you pick out that there is a duplication of names?
Okay, so thank you. Duplication, it takes place through sometimes oversight or maybe mistakes. There might be a mistake where the registrar allows identical names to exist on the database. or it can be maybe a case of similar names. But in any case, if somebody has an objection to say this name is similar to my company name, they can still submit an objection to the registrar, and there's a due process provided for that. Currently, the system we use for checking names is sufficient to prevent duplications. But where duplication does take place, there is due process. And another, usually the practice is that whoever incorporated last must change their name in the event that it is the registrar who made the mistake, or where there is perhaps maybe business risk. Usually we allow for a discussion before we go through a hearing process to actually perhaps identify the rights existing, whose rights have been violated. So there are also mischievous cases where people deliberately register a company very much similar to what they know to be an existing company with slight variations. If the registrar misses it out, then sometimes the registrar is overtaken by events where it becomes a civil matter and it goes through a court process. But there was also suggestion that shouldn't we have a tribunal specific to companies? And I think that's still a viable option where we can put, for example, intellectual property, they have a tribunal specific to issues to do with intellectual property, so that their cases do not have to join the queue with everything going to the High Court. A tribunal might also be an option. But as the office is concerned, there's a due process for that. One of the functions of the registrar is to be a presiding officer, to deal with the disputes like that, where he can make a determination and a decision. And once that decision has been made, it must be enforced. And if you don't agree, you can then appeal higher.
There's a question from Prince Fumo Jenna. He wants to know the reason behind scrapping the need for a company to state its objects.
Because, okay.
Thank you. A company is a person. And when you are born, you are not told you are going to do this, you are going to do this. It's natural. It happens because you are a person. So the law says that you will be able to perform all functions that any person can perform insofar as it is possible to do such things, except marrying, maybe. But otherwise, we believe a company can do anything legal. So this is not new, really. It is, I think it is universal development of jurisprudence where the ultra-virus in general was removed from almost all legislation, not just in Zimbabwe, but in South Africa, I think in our neighbors. So it is almost an international development, but really to restrict people to say, do this and do that and carry out these functions. We know very well that most of the investment companies that are incorporated in this country are doing no investment at all. Many of them are butcheries, they're selling products, which is fine. So really, we want to remove the burden of having to state objects. And also it simplifies our job in that we won't have very thick documents being filed in the office, which we know really to be just paper.
All right, thank you for that. To our guests logged in, please note that this is the first in a series of 4 sessions. So we might not be able to address everything in this particular session. I'll just be picking out some questions which I think are relevant to this particular session and hold the other questions maybe for future sessions. Mr. Chair, there's a question from Amos Manzonzo. He wants to know whether you have a platform for e-filing of annual returns.
Okay. I think there's a lot of questions concerning electronic filing in general. We don't have electronic filing. We are a manual system. We are a paper-based system. Yes, the law talks about electronic registry because the law is anticipating the registrar must implement an electronic system which will facilitate e-filing. I could talk about that later. Maybe I can say a few things about it now. We already have a process going on where we have identified what we need done in terms of electronic filing. We are trying to benchmark against the best in the world to be able to implement a system robust enough to allow anyone, anywhere to file and receive feedback without necessarily coming to the office. There was also a question to do with corruption. I was hoping to attend to it later. Corruption really happens at certain junctions. We all know where corruption happens, where public and private meet, there's likely to be corruption. Remove the junctions, you deal with corruption. So electronic systems will remove the junctions where people come to the office. It is necessary that the office functions without people having to come to the office. That way, you don't deal with people face to face. You remove opportunity for corruption. And therefore, in terms of the electronic system itself, it goes through due process, procurement, and also acquisition of the system, implementation, testing, and finally launching. And that process has started, and I'm hoping that COVID has disturbed a lot of things. Some of our partners needed to travel to Harare to help us with the process, but now we are not sure when that will be possible. But if it had not been COVID, I had promised the people wherever I was going that 12 months I'll give you a system. But now I can't repeat that.
All right. There's also other questions on re-registration. Is this process free? This is the question from Prince Kumojena. And also, do companies re-registering have to go through the filing of company returns before they can re-register, or there's a waiver for that process?
All right, re-registration. I would do, before I answer that, I want to encourage participants, business people, practitioners to buy the Companies Act, buy statutory instrument SI 46, buy statutory instrument 47. You need those three documents. You cannot rely on a presentation. You really need to have it on your shelf. Now, in terms of section 303, it is very specific how you re-register and what you must do. So re-registration is not free. There is a fee to it. It's a very small fee, very, very small fee, and which we want to review so that it's a proper fee. Currently, it's very small. And also, re-registration requires that you can update, but you do not forfeit obligations. You can update, meaning to say, you can, as you register, you make changes in the proper way, but you must be up to date. The whole idea is to separate functioning companies and those that are not functioning. A company that's not functioning, how do I identify it? By the state of annual returns. If it's not submitting annual returns, it's not functioning. If you are functioning and you are not submitting annual returns, then you need to correct that, because you know you will be considered as a dysfunctional company and therefore will be dissolved. So yes, it's not free, but you pay a nominal fee, and also you need to update and make sure that it's up to date. There have been submissions by some, I think this is the second time it's coming, to say, why don't you just give waive the fees? It's not the registrar who can waive fees. The registrar is an agent to collect fees on behalf of Ministry of Finance. So it's not our money. It's a Ministry of Finance money. It's a longer process. We can't just say it makes sense, let's waive. So that discussion also is taking place elsewhere.
Thank you very much, Mr. Mushayi. Before I allow you to proceed with your presentation, I will give us a message once again from our sponsors. Maisha Health Fund Zest Package. Maisha Health Fund Zest Package. This has been, we have introduced a premium medical aid package for you called Zest. Zest is indexed against market prices and gives you access to world-class health care. We invite you to join Zest Premium Package today. For more information, call our dedicated team on 0774 222 696 or 0771 222 621, or email us on sales@maishahealthfund.co.zw or corporate sales@cassavasmartech.co.zw. You are tuned into webinar hosted by IoDZ and powered by Sande. And we have Mr. Mushayi. He's taking us through an overview of the company, of the new companies and other business entities act. And he's just giving us an overview of the provisions and act and in the regulations. You can proceed, Mr. Mushayi, with your presentation.
Oh, let's talk about bona vacantia. What is it? It simply means that if there is a corporate that gets dissolved for whatever reason, and then that corporate is wound up and it had property somewhere, and that property remains unclaimed, then that property should be advertised so that those shareholders who may be somewhere can lay claim on that property. And also, if third parties, creditors, whoever was connected to that company, then there must be a process of laying claim. And if indeed there isn't any response to that effect, the property shall vest in the state. It's not entirely a new process. It's existing in the, I think it's the Deeds Act and other legislations where such provisions are in place to prevent really derelict properties and land. So there is an operation, there's a system, how it happens, where there's an application of an order. It can only take place with a court order. And the Attorney General must make an application. It's not the Registrar per se, it's the Attorney General who makes an application. And then that application goes through due process. And then there is a publication, there are notices. And then after that court process, then there is an execution through the sheriff. Civil penalties. I've already mentioned that there was an effort, a deliberate effort to decriminalize all penalties where possible so that they become civil penalties. This is intended to really make sure that business functions as business and we avoid the laborious process of having to take people to a criminal court for perhaps mistakes that can be corrected by a fine or a penalty. So there are categories for several penalties. Inspections. Okay, the registrar, once again, apart from being a licensing authority, is also an inspector. He is now empowered in terms of section 38 to 40 to 57 to put in place a section for inspection where he can release inspectors on invitation by business or on a grievance submitted by a third party or on observation that there is something going on which he needs to get very close to see. So there are, of course, there are limitations to what he can do, where he can go, and how he can get in. So the registrar can actually make inspections. So there are types of investigations where he can be involved. And I think the most important one is actually bullet number 2, on the request of minority stakeholders. These are perhaps the disadvantaged shareholders where you own maybe together, you own maybe less than 1% of shares and you are never invited for an AGM. The notice comes a day after the meeting is over. It's very common. People deliberately, because they know you might make noise, you might demand dividends and things like that. You can request an investigation and the registrar can institute an investigation and demand that another AGM take place. Determine ownership and control. Sometimes there is a wrangle and it's not difficult to determine, but simply people don't want to meet on a table and to discuss issues. So the registrar can actually use his convening power to bring people to the same table, discuss it and resolve it. So he makes a report, a copy of which goes to his minister and the concerned entity, whoever has instituted the investigation. If it's at the request by minority shareholders, then he must report to those shareholders. If it is by invitation of the High Court can actually demand that the registrar makes an investigation and the report to court. He also releases a report. But if he finds out that whatever comes out of the investigation is of national importance, then it must be published. Electronic registry, I've already mentioned that there is intention by this act to establish and maintain an ICT system for transaction and processes, also to allow for digital storage. And the registrar shall, for purposes of regulating the use of electronic registry, by registered users enter into user agreements with each registered user. Now, when a registered user is defined in the Act itself, but it does not really cut out or ring fence the process from maybe ordinary people who would want to use the system. No, an ordinary person can still use the system, but if you want to use the system as a consultant, you need to get into an agreement with the registrar, which is in a simple form. There's a form for that purpose. I just want to take you through some of these pictures. Some of you who are not familiar with the registry, this is where your company is. We stack them like that in an envelope. These are newly incorporated companies. This is 2019. You can see that each heap has got 100 companies and each file is in an envelope. So it's very thin. It's very thin and it's very neat because it's the beginning. It's 1 year old, okay? But as life goes on, they become like that. They grow, wear and tear because of handling. Generally, as long as these files are accessed, on an average day, we pull about 300, 500 files. And that's a lot. And some files are more active than others. They can be pulled maybe twice a week. And that is very difficult for the personnel, for the office. Now, there are the older files. You can see how thick it becomes. You have volume 1, you have volume 2, you have volume 3. So this system is not sustainable. We need to move away from this. This is the current system. Yes, it's working to some extent, but we want to depart from it quickly. I've got a whole list of forms. I don't know if I have to go through that. These are just a summary of what you find in your regulations and just the highlights of what you'll find in your regulations. But what I really wanted to emphasize, maybe going back to this, is to emphasize the due process that's taking place. We would want a lot of support and ideas, how you would want, especially now that we are at the development stage where we are implementing changes, moving away from the manual system to the electronic system. We are at a point where we are doing a kind of a statement of user requirements. What exactly do you want the system to do? We know what we, as an office, we know, but it may not be so clear when it comes to the client. I have questions and submissions to say we would want our system to allow interaction, to allow blogging, to allow feedback. Wonderful. That's part of the exercise. We also have an arrangement where we have a team of people working together with the registrar to make sure that we have milestones that we need to achieve in a specific period. So in terms of starting a business and in terms of ease of doing business, we do have teams, and these teams include private sector. They also include mainly business sector together with government. So it would be good to, we do have a few business persons on our teams that are participating specifically to help the registrar not to miss out any details as they seek to automate processes. Now, it's not just automating processes, it's processes and the registry itself. We would want to make sure that the registry is has the integrity to be reliable anywhere in the world. Anywhere in the world. I know some people have criticized the registrar that he sells information. Part of it was to perhaps to control access to information, not so much to deny access, but to make sure that the people who really seek information must get the correct information, and also to control. I know there have been submissions to say, oh, why should everybody have access to my file? No, when a company is incorporated, usually it's in duplicate. The client gets his copy. That's your file. The one which remains in the registry is not your file. It's public file. Everybody can look at it and see what's going on. because it's necessary that information be disclosed so that business decisions can be made from a position of sufficient knowledge. Thank you very much.
All right, thank you very much for your presentation, Mr. Mushayi. So we have a number of questions coming in, and I noticed you have shared some pictures of the state of our register right now, of our company's register. And there are questions coming in expressing concern about loss of documents and expressing concern about the backlog with the company's registry. And the questions are, will this new act help improve the quality of service at the company registry offices?
Thank you. I think the questions, I recorded a few as well, where people are concerned about the backlog and also the implications in terms of turnaround. Like I said, the Companies Act itself has already made provisions where it requires the registrar to put in place tools to help him do his job. And those tools are ICT. So a lot of the complaints that come, the backlog itself, let me explain the backlog. Part of the backlog has to do with this kind of thing, the state of the registry. It's not very easy, for example, to find the file there. It may take you maybe 2 days or 3 days. You will find it eventually. But perhaps that lead time does not really correspond to the turnaround time you are expecting, because you are making business decisions and you want certain changes implemented before a certain meeting, before a certain engagement. And then if that does not tally or dovetail, then there's concern. We are aware of that. So now, because the registry is this state, this registry must change. And to change it, of course, there are certain physical interventions we are making to improve filing, to buy shelves. And now the files are crowding the people out of offices. And the people now, we are having to move people around so that we make room for files. We will continue to have kilometers and kilometers of paper every year. We will, if we line them up, we'll get to Botswana with too much paper. We just need to move away from the physical file to the electronic storage system. We do have the hardware in terms of server space, a lot of server space. That's not a problem. What we need is the system. And that system, I said, there's due process going on right now to acquire such a system. And we already have Treasury. Let me say condolence to say you can access financing for this, which is the biggest issue, I think. So in terms of backlog, yes, definitely we have a backlog, and we are using COVID time to deal with the backlog. Unfortunately, I can't bring all my examiners into the office because there's a limitation as to how many people I can bring in. I hope I answered that.
Yes, yeah, you answered very well. I think we have kilometers and kilometers of files, and the files are taking up all the space, and there'll be no more space for the people. There's just one question maybe I'd want you to address before we wind up. There's one which is maybe one or two. It's talking about the new Companies Act and the placing companies under judicial management. Is this going to help companies rehabilitate? Because there's a question which addresses the issue of the adequacy of the old Companies Act in helping companies rehabilitate companies that are under judicial management.
Okay, thank you for that. I think the correct terminology is business rescue. Business rescue is under Insolvency Act, and it's now under the jurisdiction of the master. So is it the master of Ministry of Finance? I'm not too sure between the two of them. But yes, there is a business rescue provision where companies really can be assisted to recover. But as far as the Registrar of Companies is concerned, he no longer has a role to play there. All he can do is to remind a company that they are falling behind in terms of submitting annual returns. But if they are failing to submit annual returns because of pressure or maybe failing to operate, then that jurisdiction is no longer with the Registrar of Companies. The Registrar of Companies is only concerned with the birth and the death of a company. What then happens after you are dead and you are resurrected, it's under the master.
All right. There's also a question here which talks about the companies, the shelf companies that are already in existence. Will these be automatically deregistered for failure to file returns? Those that are already in existence, shelf companies.
All right. Share of companies, yes. If there are no returns there, we will remove them from the register. But in terms of re-registration, let's not confuse things. Share of companies that are registered as share of companies and are not submitting returns should be removed immediately from the register. Then re-registration is mainly to do with companies that are in business, that would want to continue in business, and therefore will come to notify the registrar and the public that we are still in business and we are active. We want you to keep us on your register. That's the purpose of re-registration. So anybody who does not really comply with that, then it's a signal to the registrar to say, this one is no longer in business, that one is no longer in business. And the deadline is still February 2021. And like I said before, I've made submissions to say I would want it extended because I want it to coincide, re-registration to coincide with an ICT system. So that when you re-register, you are re-registering on an ICT platform, not to have another file again, some more paper and some more paper. That doesn't help the process.
I think that should be all. Thank you very much, Mr. Mushayi, for coming through to give us a breakdown and overview of the new Companies and Other Business Entities Act. And I think my guest will agree with me that this was a very fruitful discussion and that this was an insightful topic because it's very crucial because, you know, companies, like you said, they're just like human beings, they're legal personas. So you need to know your rights, you need to know your obligations. And this is the first of 4 sessions that are going to be held by IoDZ to discuss and unpack the new Companies and Other Businesses Act. And I would invite our guests to join us once again for those 4 sessions because this was just the tip of the iceberg. We have not started to unpack the entire act. So we're just looking at an overview in the general regulations and the general SIs. And before maybe we conclude, there's one who wanted to know if these are available electronically, that is the Companies Act and the SIs, the 2 SIs. Can these be accessed electronically?
Oh yes, you can access them on the www.dcip.gov.zw. You can download the act, you can download the statutory instruments, or you can buy straight from print flow, which would be hard copy. So if you want soft copies, I will repeat the website again, www.dcip.gov.zw. You can download from there.
All right, thank you very much. To our guests who joined us, thank you very much for sparing your precious time to listen in to our webinar, and we invite you for more webinars. We're going to be conducting 3 more sessions where we'll unpack the Companies Act, and the dates will be notified to you in due course. And we'd also want to thank our major sponsor, Sande, for making this webinar possible. And we'd also want to thank Mover, EcoCash, Cassava Smart Tech for sponsoring and helping us to bring this webinar to you. And thank you to Mr. Mushayi for sparing your time to come in and to unpack the New Companies Act for us. Otherwise, that is all from us today, and look forward to joining you, to having you with us for future webinars. And to those who are not yet members of IoDZ, you can kindly contact our admin, our personnel, on how you can join IoDZ. As you can see, we are here to provide for you the most up-to-date information on our current affairs. Here we are hosting the webinar on the New Companies Act, which is a crucial act, which some might not even be aware of right now, but which will affect their day-to-day operations and the way they do their business. So please join us. Feel free to contact Kathy and her team on how you can join IoDZ. Otherwise, enjoy your day. Yeah, we can.
Before we have the left.